on SDGs today. Before we start our agenda, let me inform you of some rules for the event. Please adjust your name using format institutions underscore name or during the lecture. Please turn off your audio and only turn on the audio when the moderator gives the chance. Third, please fill your attendance at bit.ly/attendance underscore underscore GLS as the Zoom chat room. Participants who wish to ask a questions during the Q&A session, please send your question to intip.in/Q&A/GLS/SDGs. The link for questions also listed on the Zoom chat. Or you can ask directly by clicking the raise hand feature. This lecture series committed to strengthen the international partnership and to provide a world-class learning environment. Institute Technology 10 November is inviting global students and young researchers to enjoy world-class lectures delivered by world's best lecturers through guest lecture series on UN Sustainable Development Goals. And today's theme is Rule of Law and the Common Law Legal System, which we delivered by our
Hello, Miss Desi.
speaker, Prof. Webb, and the lecture if certificate in the next agenda. Let me introduce our moderator, Dr. Irfan. Okay, he is a senior manager for international partnership at ITS Global Engagement, and also he is a lecturer at Department of Electrical Engineering ITS, and he got his bachelor degree from Universitas Gadjah Mada and his master degree from the University of New South Wales and his PhD also from the University of New South Wales. Now, without further ado, let's proceed to the main agenda. To Dr. Irfan, the time is yours.
Thank you very much, Desi, for the really kind introduction. So, good morning, Professor Webb. Good evening, maybe to everyone else in Indonesia and other countries around Indonesia. I see some people from Malaysia as well. Good evening. So today we have Professor Henry Webb from Indiana University of Pennsylvania, United States of America. He will be presenting and sharing the topic of let me get this right, rule of law and the common law legal system. I'm aware that some of us, maybe most of us are undergrad students, maybe from different backgrounds, science, engineering, maybe from business management. Let's try to learn something from this. We really believe that this is related to all of us. We live in a society, you know, we have law that bind us together. And so, yeah, I think that's a bit of the intro. Let me read his biography. Professor Henry Webb did his bachelor's degree at the University of Mississippi, Bachelor of Business Administration. He received his Juris Doctorate, JD, from Lewis and Clark Law School, and also MBA from University of Georgia, Terry College of Business. Regarding his professional and working experience, since August 2015 until now, he's assigned, so he's a professor at Indiana University of Pennsylvania. Professor Webb is assigned to design, coordinate, and teach in summer study program, Canto University, Vietnam. From 2014 to 2015, Professor Webb was an associate professor of law in Appalachian Professor of Law, Director of Legal Research and Writing Program. Sorry for mentioning that incorrectly. 2011 to 2014, he was a lecturer in legal writing and advocacy skills program at University College of Law. Between 2008 to 2011, He was lecturer and course leader in RMIT University, Vietnam. Between 2003 and 2007, he was an associate attorney in Morris, Manning and Martin LLP. He has become a visiting professor in July 2019 at An University, Vietnam, March 2019 at University of Pécs, Hungary, and at June 2017 at Vietnamese German University of Vietnam. So it's a great honor for having Professor Webb today. Please, I think let's all welcome Professor Henry Webb. You can start your talk. Thank you.
Okay, thank you very much. I'm very happy to be here. I appreciate ITS setting this up for us. Good evening. It feels strange to say good evening because it's 7 o'clock in the morning here. I had to get up early and come to my office much earlier than usual, but I'm happy to be here. I'm going to share my screen now. Hopefully this will work. Just a second.
Yep, we can see it very clearly.
Okay, great. Okay. So yeah, I'm going to talk today about the rule of law and the common law legal system. And I understand that ITS is a technology school. And I understand that a lot of what I talk about today may not be something many of you are familiar with. And I'll try to keep it simple and straightforward as I can. I'm very flexible. I'm very easygoing. If you have questions, please raise your hand and the moderator can stop me at any point, and I'm happy to answer any questions anyone has or to go into more detail, etc. This is part of a guest lecture series, as you know, about United Nations Sustainable Development Goals. And I'm going to talk about Goal 16, which is about peace, justice, and strong institutions. And it's an interesting topic for me. It relates to what I teach as a professor of business law every day here in the US. This is a topic that I teach about all the time. So it's an interesting experience for me to teach people in Indonesia about this topic and to try to present it in a way that you can understand and relate to. I'm going to talk today about my background, which the moderator already went over in some detail, so I'll be quick about that. I'm going to talk about the rule of law generally. What do I mean when I say the rule of law? I'm going to talk about corruption and the link between the rule of law and corruption. Finally, I'm going to talk about the common law legal system, and we will wrap up by doing an example where we will analyze a real legal case, the same way that lawyers do in the US every day. Okay, the same way as a lawyer, I would take in a case and begin to analyze that case and apply the rule of law to that case. I'll start with the most important point I want to make today probably is I've been lucky enough to visit your beautiful country two different times. In Christmas of 2008, I was living in Vietnam and teaching in Vietnam at the time. And my wife, who was just my girlfriend at that point, we were not married yet, but my wife and I spent Christmas in Bali, and we loved it so much that when we got married 2 years later, we spent our honeymoon in Bali. We went back to Bali. So I've been there twice, and I know Indonesia is much bigger than Bali, but we loved Bali so much. That's where we went 2 times. It's one of our favorite travel experiences of our lives. The people were so friendly. It is such a beautiful place, as you know. We love the food, we love the culture, we loved everything about it. The way that I came to be speaking with you today is because last year in 2019, I taught in an exchange program in Vietnam for a university in Vietnam. And we had mostly Vietnamese students, but also students from other countries. And one student was from ITS Surabaya. And she and I kept in touch after the class. My hope is that at some point I can come and teach a course there at ITS Surabaya in person. But with COVID, with the pandemic going on around the world, here we are by Zoom. So I'm hoping for 2021, maybe I will be able to meet some of you in person, and I will see a different part of Indonesia other than Bali. So we'll see. I'm not going to go through my background in too much detail because the moderator already did. I have a law degree, a Juris Doctorate degree in environmental law. I also have an MBA. I practiced law for about 11 years before I got into academia, and I taught in Vietnam for 4 years. I taught in Qatar in the Middle East for 3 years, which was a very interesting experience. And then I've been teaching in the US since 2014. Okay, we're going to talk about the rule of law, and I'm going to be very clear and give you a very detailed definition of what I mean by the rule of law, and this comes directly from the United Nations. So they say the rule of law, let me move this a minute, just a second, is a durable system of laws, institutions, norms, right, our values and norms as a society, as a culture, and community commitment that deliver. So it's the overarching system, right, in our community that delivers these things. And we'll talk about each of these in detail. Number one, accountability. Number two, just laws, which means fair laws. Number three, open government. And number four, accessible justice. So let's talk about each of these. What do we mean by accountability? The government, as well as people outside of the government, are accountable under the law. Okay, the government not only creates the law, but the government is accountable under the law. If you're part of the government, the laws still apply to you. It's not like the government creates the laws and they apply to everyone else and not the government. The laws apply to the government as well. And that's important because there are countries around the world where that's not the case and where people in the government have kind of a higher position. They're above the law in some cases. And that's not good. That's not what the rule of law is about. So the first is accountability. The government is under the law just like everyone else is. Number two, just. And by just, we mean fair. So fair laws. To me, this is the most important point. If I had to limit this to one point about the rule of law, this is the point I would make. The laws are clear. We can understand what I mean, if we can't understand what the law says, how can we abide by the law? How can we follow the law or make sure we're following it? So the laws are clear. They're publicized. They're available. We can go and find the law and make sure we understand what the law is. They're stable. They don't change from day to day. They're going to change over time as society evolves and technology evolves, but they're going to be fairly stable so that we can predict how the law will apply. Here's the key. They apply evenly. They apply evenly to everyone. There's not different classes of society where the law applies to some and does not apply to others. They apply evenly to everyone in society, no matter who you are, no matter what position you have, no matter how rich or how poor you are. The law applies evenly to everyone. Okay, and then finally, they protect fundamental rights, including our security, including our ability to contract, to engage in business, including our ability to own and protect our property, and finally, our fundamental human rights. This is a very important point. And again, as I mentioned, if I just had to pick one of these aspects of the rule of law, this is the one that I would focus on. Number three, open government. The government needs to be transparent, not in secret, not conducted in secret. It needs to be open and transparent. The processes by which the laws are enacted, that means created by the government, administered, right, operated day to day, and enforced. How penalties are applied when people violate them. They need to be accessible. We need to be able to understand how the government does these things. They need to be fair, again, and they need to be efficient. It doesn't need to take any more time than is necessary. And then the last aspect of rule of law, accessible justice. Okay, justice is delivered in a timely fashion, again, quickly. If I'm charged with a crime, for example, I don't want to go sit in jail for 6 years before I can have my trial. I want to have it fairly quickly. Maybe I'm innocent and I should be home with my family, not sitting in jail. So this needs to be done timely. It needs to be done reasonably quickly. And it needs to be delivered by competent, ethical, and independent representatives and neutral. The legal system, they need to be competent. They need to understand and be trained in the law. They need to be ethical, honest people with good values, and they need to be independent. They can't have an interest in the cases, in the disputes before them. They need to be independent third parties who don't have an interest in the cases and can decide them fairly. They need to have adequate resources, courtrooms, the ability to do the necessary legal research, proper staff, okay, technology, right? And they need to reflect the makeup of the communities they serve. They don't need to be people from outside the community brought in who don't understand how the community operates, They need to be part of the community, from the community. So that's a lot. Let me back up just a minute. Accountable, fair, open and transparent, and accessible, right? This is what we're talking about when we discuss the rule of law. And it's important that we understand that before we move on. Now, I want to talk about the link between the rule of law and corruption. And by corruption, it's one of those terms that I think most people have an idea of what it means. What does corruption mean? But I want to make sure we all have the same definition, okay? For today, corruption is going to mean dishonest or fraudulent, right? False, we're committing fraud. Dishonest or fraudulent conduct by those in power, by the government, at all levels, right? The legislature, the people that write the laws, law enforcement, the police, the investigators, okay, judges, people who run agencies, people at all levels of the government. So dishonest or fraudulent false conduct by those in power, typically involving bribery. Well, what's bribery? It's paying money to someone, we say under the table. I don't know if you say this in Indonesian or not, but it's paying money to someone under the table, unofficially, right? Do this favor for me and I'll give you some money. Secretly, right? Not reported, not officially, but under the table. So dishonest or fraudulent conduct by those in power, those in the government, typically involving bribery, paying money under the table for a favor. This is the opposite of the rule of law. If you think about what we just discussed, the rule of law is to apply evenly and fairly to everyone. This is the opposite. This is saying, I want to be treated differently. I want to be treated special. And I'm going to pay money to be treated differently, to be treated special. Okay, so it's the opposite. Corruption is the opposite of the rule of law. This is from the United Nations, okay, a statement on the rule of law and corruption from 2005. They're talking about the connection between the rule of law and corruption here. Corruption is a serious impediment, obstacle, problem, right? Corruption is a serious impediment to the rule of law and sustainable development, sustainable economic development. The United Nations recognizes the negative impact of corruption, which obstructs economic growth and development, erodes public confidence, legitimacy, and transparency. And here's the last point. This relates to what we just discussed, and hinders, right? Makes difficult the making of fair and effective laws, as well as their administration and enforcement and adjudication. So this relates back to the definition we just looked at of the rule of law, and corruption is the opposite, right? Corruption hinders or stops or obstructs the fair administration of the rule of law. I lived in Vietnam for 4 years, as I mentioned earlier. Vietnam is a fairly corrupt country. Okay, there's a global index of corruption. They rank 180 countries, and Vietnam is 96th. So there are 95 countries in the world who are less corrupt than Vietnam. They're in the bottom half. It's not great. It's not great. It is viewed by many people who live there and do business there as a fairly corrupt country. It is a country where you can pay money unofficially, under the table, in many circumstances, to get special treatment under the law. I was a tourist in Indonesia. I don't know much about Indonesia culture and if it's corrupt or if it's not corrupt. So I'll just talk about Vietnam today. Maybe some of the stories I will tell you will sound familiar, maybe not. I'm going to tell you a few stories about experiences I personally had in Vietnam involving corruption. When I tell these stories in America, people are shocked. They can't believe it. When I tell these stories in Vietnam, people smile and they say, that's how culture works here, right? That's how things are done. It's not that big of a deal to them. Okay, so here's the first story. My friend owns a company in Ho Chi Minh City, the biggest city in Vietnam, about 12 million people. And his company imports nutritional supplements for bodybuilders, for weightlifters. So if you lift weights and you want to get big, you take these supplements, right? A shipment of new supplement arrived at the port in Ho Chi Minh City, and the customs office called my friend's company and they said, we've got this new supplement here. We can't release it until we test it in our laboratory, right? We have a customs laboratory We've got to test it for quality and safety, and we can't release the shipment to you until we test it. And my friend said, well, how much will this cost and how long will it take? And they said it will cost 3,000 US dollars and it will take 6 to 8 weeks. And my friend said, I can't wait. I need to sell this now. I have to supply this to my customers now. I can't wait 6 to 8 weeks. So he got his office manager to speak with the customs department, and they negotiated for a while. They went back and forth, and the customs officer said, we can expedite, right? We can make quicker, okay, the testing and release the shipment to you today, not 6 to 8 weeks from now, but today, if you can pay us $600 in cash immediately, 600 US dollars in cash immediately. So my friend's company agreed. I said, okay, we'll pay the fee to expedite the testing. And they said, we have a sample here at our office. Where should we send the sample of the product for testing? What's the address of the laboratory? And the customs official then said, no need to test it, right? Just pay us the $600 and we will release it. So there was never going to be any testing. And the whole concept of this testing was really just a way for the customs official to get as much money as he could from my friend and his company. He wanted 3,000, he got $600 in cash. He released the shipment with no testing at all. That's corruption, right? He's a government official. He works for the government's customs office. He's taking money under the table to do a special favor for my friend's company. Here's another story involving my same friend, same company, okay? The accountant for his company figured out that one of the employees had stolen, we call it embezzled, right? Embezzlement, but he had stolen a lot of money from my friend's company, a lot, $170,000 over a few years. And my friend, of course, fired the employee. And under Vietnam's employment laws, he sued and claimed that my friend improperly fired him, improperly terminated him. And it was a problem for my friend. It was a real lawsuit that he had to go and fight, right? During the lawsuit, the judge assigned to the case invited my friend and his lawyer to meet with the judge privately in the judge's office. And the judge told my friend and his lawyer, if you will pay the judge 10,000 US dollars, you will win the case. And my friend's lawyer advised my friend, I think you should pay it, right? If you don't win this case, you will pay much more than 10,000 US dollars to this employee that claims you fired him, terminated him improperly. So I recommend you pay the judge and win. And so my friend paid the judge $10,000 and won the case. Again, in America, this is a crazy story. Like, I can't imagine a judge asking a party, one of the parties in a case before, to pay him money to decide the case in their favor. And my friend, who's an American, he lives in Vietnam, but he's an American, he was shocked and he was surprised. But his lawyer said, this is the way we do it. And if you want to win the case, I recommend you do pay the attorney. So my friend did, and he won the case. Here's one more personal to me. So I taught for an Australian university in Vietnam, and my office window looked out on a busy highway. And I don't know why, but right in front of our building, the Vietnamese police like to sit there on their motorcycles and pull speeders over. People would be speeding down the road and they would pull them over, right? So all day I would see the policemen out there on the road, pulling people over all the time. Well, one day it was my turn. Okay, I was driving down that same road, and maybe I was going a little fast and I was pulled over, and the police officer said, you were speeding? And I said, okay, sorry. And he said, I want 500,000 Vietnam dong. Now that's the currency in Vietnam. It was about 25 US dollars. And I thought about it and I said, no, I said, I want you to give me a ticket. I don't want to pay you a bribe to make this go away. So you just let me go, right? I want you to give me a speeding ticket and I'll come to court and I'll, fight the case. And he said, no, you pay me $500,000. You can go, I'm sorry, $500,000, $25, and you can go right now. No need for a ticket. I said, no, I want the ticket. I'm not paying you anything. He said, okay, 400,000. I said, no, give me the ticket. He said, 250,000. I said, no. I said, give me the ticket. He said, 100,000. It's like $5. Okay. I said, no, I don't want to pay you a bribe. Give me the ticket. He said, go home. Right. I didn't pay him anything. He did not want to give me a ticket. That was not his purpose. And all the time he would spend giving me a ticket is time he could be spending pulling over other people and getting money from them. So finally he's like, just go, don't pay me anything, just go. And I left, and I didn't pay him anything, and I didn't get a ticket. And then I understood that's what they do all day long. The police sit there and they pull people over. They're not giving them tickets. They're just taking money from them. Okay, go. It's bribes all day long, under the table money. Okay, last story about Vietnam. And this involves a lot of money. This involves millions of dollars. So I did some consulting for a foreign university that wanted to come into Vietnam and build a campus in Vietnam. And they were very clear with me, with everyone on the team, with the Vietnam government. They said, our laws in our country where we're from, our home country, prevent us from paying bribes in other countries like Vietnam. And if we pay bribes in Vietnam, we can go to prison, not in Vietnam, but back in our home countries. We could go to prison. So we have to do this without paying any bribes. We have to build this campus and hire these people and start this university the right way, the honest way. We cannot pay any bribes. Okay. And while I was working with them, this process was going on. And for over a year, they couldn't get anything done. They couldn't get the construction started. They couldn't get the permits they needed. They couldn't hire the people that they needed to hire, because every time they tried to do something, someone from the government said, pay me some money, right? Give me some money. Okay. They couldn't get anything done. So I eventually stopped working with them. It did not look like the university was going to happen in Vietnam, and I stopped working with them. But later I found out it did happen, and they were able to build their new campus. And through a friend of mine, I visited their new campus one day. And while I was there, I was talking with my friend, he worked for the university, and I said, wow. I said, how did you figure out? How did you get it done? How were you able to build the campus without paying any bribes, right? And he started laughing. And he said, of course we had to pay them. If we wanted our university, if we wanted to build our campus, if we wanted to get the permits we needed and to hire the people we needed to, of course we had to pay. So that is corruption. And I don't mean to pick on Vietnam. I love Vietnam. My wife is from Vietnam. My son was born in Vietnam. I'm not picking on Vietnam. And again, it's only 96 out of 180. So there are apparently much worse countries in the world. But those are just some of my personal experiences with corruption during my fairly brief 4 years in Vietnam. All right. I want to talk now about the common law legal system. And this may be new information for most of you or all of you. There are two main legal systems in the world today, and one is called the civil code legal system, and the other is the common law legal system. And that's what I will talk about in more detail today. Okay. In a civil code legal system, the government tries to capture all of the law in writing, in books. Okay. Civil laws that don't deal with crimes, that are not criminal laws, civil laws are captured in something called the civil code. And they literally try to write a law to cover everything that might happen in society. Contract law and property law, it's all captured in written laws. For criminal laws, there's also something called the criminal code. So civil involves money, claims for money, usually. Criminal involves crimes, where you've broken the law in a way that you may pay a penalty to the government, or you may go to jail, or in some countries, if the crime is bad enough, they may kill you. They may execute you with the death penalty. Okay, so that's a civil code legal system. They try to capture all of the law in writing in these written books that we call collectively the code. Common law is different. We'll talk about that. My understanding, and again, I'm not an expert on the Indonesian legal system. but my understanding is it is a civil code system with some customary, historical, traditional law used to solve disputes at the village level, small town level, and then also some elements of Sharia law. And I'm certainly not an expert on Sharia law. I learned a little bit about it when I taught in the Middle East, in Qatar, but I'm not an expert on it. Okay, but that's my understanding of the Indonesian legal system. Primarily a civil code system, some historical customary law at the village level, and then also a mix of Sharia law. Now, common law is different. Common law has another primary source of law. We have the codes, we have the civil code and we have the criminal code, and they do try to catch a lot of behavior, a lot of things are captured in those codes, civilly, non-criminal laws and also criminal laws, right? We have the written codes, but in addition, we have another source, another primary source of law, and that source is decisions from courts. And that's what we call common law. Common law, when someone says common law, they're referring to decisions from courts which become the law. So when a judge in a common law country like the US, like England, like Singapore, like India, like Canada, okay, when a judge in a common law country, in a country having a common law legal system, makes a decision, that decision becomes part of the law going forward. And so in the future, future parties, future lawyers and parties before a court can look back, they can point back to that earlier decision, and they can say, look, this judge decided this case, a similar case, this way, and this is how you should do it as well. So in addition to having the codes, right, in addition to having the written laws, we also have this body of law that is made of judges' decisions, courts' decisions. And those decisions also become part of the law. And again, it's the judge-made decisions, the court-made decisions that we call common law. Okay. Another name for it, as I have here on this slide, is judge-made law. And that's the decision made by a court after considering an actual dispute, an actual case, we call it, an actual lawsuit between the parties to that case, to that lawsuit. All right, this is important. Judges don't come into the courtroom and make up situations and decide them. They don't engage in hypotheticals. They make rulings in actual cases where someone believes they have a legal case against someone else and filed a lawsuit, which costs money and takes time, okay? But that becomes an actual dispute, an actual case before the court, and the court has to decide. Party A wins and party B loses, and here's why under the law. Here's why party A should win and party B should lose under the law. So again, judges are making these decisions that become law in real disputes, not in hypotheticals, not in imaginary made-up situations, in real disputes. These prior court decisions, these decisions in the past, are something called legal precedent. Precedent just means something that came before. All right, so they're cases that came before, and they influence and govern, help decide how future similar cases should also be decided under the law. Okay, so in the future, if actual disputes occur that are similar to prior disputes, the court will consider how those earlier courts decided similar case, and they may rule in the same way or certainly in a similar way. Very different from a pure civil code legal system. This is one of the most important things I will talk about today. And unfortunately, it's in Latin, right? Latin's a dead language, but in the American legal system, lawyers and judges still use a lot of Latin. In my business law classes, I try not to use any Latin or very little Latin, but this is such an important concept, an important principle in the common law legal system that I have to mention. And it's called the principle of stare decisis. Okay, and what that means is that lower courts, and I'll tell you what I mean by lower courts in a minute. Lower courts must follow legal precedents, earlier decisions, right, established by higher courts within the same jurisdiction, within the same area that court has power, has authority. So in America, we have 50 states, as you probably know. I live in the state of Pennsylvania. A court may only have power or authority in Pennsylvania. That's what we mean by jurisdiction. A Pennsylvania court only has power in the state of Pennsylvania. It doesn't have power in California or New York. It only has power in Pennsylvania. So a lower court must follow the legal decisions, right? Legal precedent established by a higher court in the past in the same area. So a lower court in Pennsylvania must follow a decision of a higher court, a prior higher court decision in Pennsylvania. Or what? What if they don't? If they don't, they can get reversed on appeal. So if a higher court in Pennsylvania has said, this is the law, and then in the future, a lower court has a similar case, and they don't follow that law, they don't follow that decision of the higher court, then they can get reversed. And it's very embarrassing for a judge to get reversed, because that's where a court is saying, you got the law wrong. You ruled incorrectly. And we are reversing your decision. We are changing the result. And judges are very embarrassed by that, and they don't like it. Okay, so they do everything they can not to be reversed. They do everything they can to follow the legal decisions established by these higher courts in their same state, for example. Stare decisis, again, fundamental principle of common law, of a common law system. It promotes stability. Okay, because lower courts, they can't just rule however they want to. They have to follow these decisions by higher courts, these earlier decisions by higher courts. That makes the law more stable. If I have a client and we go into a courtroom, a lower court, right? I can predict, right? I can tell my client, we have a pretty good idea of what this judge will decide in this case, because this case is so similar to another earlier case. And that case was decided by a higher court, and this court has to follow it. He has to follow it or he'll be reversed on appeal. So it gives the system some stability. As I mentioned, it gives it some predictability. I can predict for my client what the result will likely be. And also it makes it more fair, because all of these lower courts should be following the same earlier decision. And so people going before these different courts should get a fair result. They should get a similar result. Okay, so stare decisis. Lower courts have to follow the earlier decisions of higher courts in similar cases in their area of authority, area of jurisdiction, or what? Or they'll be reversed on appeal, and no judge wants that. And it's important because it promotes stability, keeps it stable. It makes it predictable so that clients and their lawyers can predict what will happen in a certain case. And it also promotes fairness, because everyone should be treated the same. The same laws should apply to everyone. Very important principle. What do we mean by lower courts and higher courts? Well, I've got a nice diagram here to show you. And I don't want to go into too much detail on this, but in the US, in the United States, there are two separate legal systems. One is the state system, as I mentioned. So if you look in this middle column at the top, it says the Pennsylvania state court system. That's the court system where I live. Okay, at the very bottom, and you see the arrow to the side going up. So the higher up in this table, the higher the court, the more power the court has. So at the bottom, in the middle, in the Pennsylvania state court system, we have the trial court level. And in Pennsylvania, that's called the Pennsylvania Court of Common Pleas. And that's the lowest and least powerful court in the state of Pennsylvania. In the middle, we have something called the appellate court level, the courts of appeals. So if you lose at the trial court level and you think the judge got it wrong, you can appeal it to the appellate court level. And in Pennsylvania, that's called the Pennsylvania Superior Court. What happens if you lose again? If the Court of Appeal says, well, we agree with the trial court, you lose again, you can also appeal to the highest court in the state of Pennsylvania, which is the Pennsylvania Supreme Court. So when we're talking about higher courts and lower courts, that's what we mean. The Supreme Court sits at the top in Pennsylvania. The Superior Court is the middle court of appeals. And then at the very bottom are the trial courts, the Pennsylvania Courts of Common Pleas. There is let me say, each state has its own state court system. Florida has its own state court system. New York has its own state court system. California has the California state court system. And they're all set up basically this same way. Okay, trial court, appellate court, and Supreme Court at the top. The federal system, the countrywide system in the US is set up the same way. At the bottom, we have the trial courts. They're called the United States District Courts. In the middle, we have the Courts of Appeal, the United States Circuit Courts of Appeal. At the top, we have the most powerful court in the country, the United States Supreme Court. So in both the federal countrywide system and also at the state level, they're structured the same way. Trial court, middle court of appeals, and Supreme Court at the top. This concept of lower and higher courts is called the hierarchy of courts. And I've got that at the bottom of the slide here. So when we go back to stare decisis and we talk about lower courts must follow the legal precedent established by higher courts, that's what we mean, okay? Trial courts have to follow the earlier decisions of appellate courts and Supreme Courts. Appellate courts have to follow the earlier decisions of Supreme Courts. Supreme Courts don't have to follow the earlier decisions of anyone, okay? So for example, a 2005 decision from the Pennsylvania Supreme Court is binding. And by binding, what do we mean? We mean the lower courts must follow it. They are bound to follow it. So a 2005 decision from the Pennsylvania Supreme Court is binding upon the Pennsylvania Superior Court and all Pennsylvania courts of common pleas going forward. So let's go back. So if in 2005, the Pennsylvania Supreme Court, you can see that's the highest court in the state. If they said this is the law in this type of case, then starting that year in 2005, all lower courts in Pennsylvania have to follow that case, have to apply the law the same way. The appellate court, the Pennsylvania Superior Court has to do it, has to follow it. Why? Because the Supreme Court is higher than the appellate court, than the Superior Court. And also the trial courts, the courts of common pleas have to follow the law as set out by the Supreme Court. Why? Because the Supreme Court is the highest court in Pennsylvania and the trial court and the appellate courts are lower than the Supreme Court, okay? And a 2012 decision by the Pennsylvania Superior Court, by the appellate court, that middle appellate court is binding upon all Pennsylvania courts of common pleas. So we'll go back again. If that middle level, Pennsylvania Superior Court says this is the law in a contract case, for example, in 2012, then all future trial courts in Pennsylvania, all courts of common pleas have to follow that 2012 decision. Or what? Or they'll be reversed on appeal. A judge will say, you got it wrong. You applied the law incorrectly. And judges don't want that. They don't like that. Now, I'm going to ask you a question. I'll answer it myself, but since we're on Zoom, but is a 2009 decision from the Pennsylvania Supreme Court binding upon the Pennsylvania Supreme Court in 2020? Is a 2009 decision from the Pennsylvania Supreme Court binding on itself, right, on the same court 11 years later in 2020? Let's go back and look at our chart real quick. Is a 2009 decision by this highest court in Pennsylvania binding upon itself, binding upon the Pennsylvania Supreme Court 11 years later in 2020? And the answer is no, it's not binding, okay? Why? Because it's not a lower court and a higher court situation. It's the same court. It's at the same level, okay? It's 2009 and 2020. It's 11 years apart, but it's the same court. If the Pennsylvania Supreme Court said this is the law in 2009, it's free to change its mind in the future. Okay, and that's one way that the law does change over time, does evolve over time with society and our values and what we believe as a people, and with changes in technology and changes in the way we do business. The law has to adapt. The law has to evolve and reflect these changes. And this is one way that happens. The Pennsylvania Supreme Court in 2020 may say, we got it wrong. We got it wrong in 2009, and we can change our mind and we can change the law, okay? This concept of stare decisis only works when you have a higher court and a lower court. When it's a court at the same level, it's not binding. They're free to change their mind in the future. All right, I'll say no, because the earlier 2009 decision is not from a higher court. It's from the same level of court. And only the earlier decisions of higher courts are binding upon lower courts. Okay, now that's a very quick and brief introduction to a very important concept that again is a fundamental principle underpinning of the common law legal system. Okay, the rule of law is important in all countries. no question. And that's one reason the United Nations is focused on it. But it's especially important in common law legal system countries. Why? Because in common law countries, courts are not just interpreting and applying the code, right? They're actually creating law. They are creating the law, just like the government, right? Just like the legislative branch of the government, the legislature, the Senate and the Congress, whose job it is to write the laws, whose primary job it is to write the laws. The courts are also making laws. They are creating laws. And you can see why the rule of law is especially important then, because they have a more active role. They're actively creating the laws governing that country. All right. 3 ways they can make law. Number 1, by creating a new law where no binding law exists. Okay, and I'll go through this quickly, but if the legislature, if the government that writes the code, if they haven't said what the law is in a certain area, then a court is free to make the law however they see fit. If the code does not address a certain aspect of the law, then a court can create the law. So the first way a court creates law in the common law system is to create a new law, a new legal principle, where the code doesn't speak to it, where the code is silent. The second way they make law is by deciding cases applying the existing law. Every case is different. The facts of every case are slightly different from every other case. And so every time a court applies the code or an earlier decision, earlier case, to a legal dispute, the facts are a little different. And that court is creating new law. What are they doing? They're saying, in this case, in this dispute with these facts, this is how the law applies. And because every case is different, every dispute is different, that's creating new law. They're signaling to future courts, this is how the law should apply in this particular dispute with these particular facts. And then the third way courts can make law in the common law legal system is by deciding what ambiguous or vague language in a law means. A lot of time, the legislature will write a law and you could read it and you may not understand it, right? There's a word in there that could mean more than one thing, where 2 intelligent people could read this law and think it meant different things. That's vague language or ambiguous language, which means it could have more than one meaning. Well, that's one of the roles of the court, is to decide, what does this term mean in this law? When the government wrote this law in the code, what did they mean? Reasonable people could read it differently, but it's the court's job to decide, what do we believe the government meant when they wrote this law? So real quick, 3 ways they make law. By creating new law where the code is silent, where nobody has decided the law yet. By applying existing law to new circumstances and new disputes. And by interpreting ambiguous or vague language in an enacted law, in an existing law. All right. The last thing we'll do today, and this is an example of common law legal analysis. Okay, so as a lawyer in the common law legal system, knowing that we have 2 primary sources of law. We've got the code, civil code or criminal code, and we've also got legal precedent, right? We've got common law, we've got judge-made law, judges' decisions in earlier cases. How would we go about deciding or analyzing a legal issue, a potential dispute? So we're going to talk about a case today called State of Oklahoma, and Oklahoma is one of the 50 states in America. So State of Oklahoma versus Bobby Plant. Bobby Plant is the name of a gentleman. All right. So we're going to pretend that we are lawyers in a law firm, right? And we've got a new client or potential new client, Bobby Plant, and he comes to us and he says, I've been charged with a crime by the state of Oklahoma. So not a civil case where it's just about money or a contract or something, but a criminal case. He's been charged with a crime by the state. That means he may go to jail, or he may pay a penalty to the government, or he could be killed if it's a bad enough crime, right? If it's we call it capital, a death penalty case, right? But he's been charged with a crime, so it's a very serious matter. And here's what he says, right? He comes into our office and he sits down with us, and here's what he said. He said, on Tuesday night, we decided to go out for drinks in downtown Tulsa. Tulsa's a city in Oklahoma. My classmate, John, was the designated driver. What does that mean? it means that John's not going to drink any alcohol. He's going to stay sober so he can drive. Okay, so the rest of them can drink. And Bobby Plant tells us, I drank way too much. He says, the next thing I remember is waking up in jail Wednesday morning, the next morning, charged with the crime of being in actual physical control of an automobile while intoxicated, whatever that is. And then he says, then he asks us the question that everyone charged with a crime asks their lawyers, right? Which is, can you get me out of this? I don't want to go back to jail. I don't want to have to pay a fine. I don't want to have a criminal record. Okay, can you get me out of this? And that's what we're going to have to figure out. To help Bobby Plant, we're going to have to figure out, was his behavior really a crime? Did he really engage in the crime of actual physical control of an automobile while intoxicated? Or did he not? We've got to figure that out before we can advise. Okay? He doesn't remember very much. He basically said, I drank too much and I don't remember anything else. Okay? What's another possible source of factual information in this case? What's the police report? Okay, if the police in America arrest someone and charge them with a crime, they have to make a report. They have to make a report, okay? And it looks like this. This is a Tulsa Police Department incident report, crime report. It's got the date and time reported, the location that it happened. The third item there, the incident type or offense, that's important because that's telling us what criminal law, what part of the criminal code the police believe Bobby Plant broke, right? What law he broke or what law he violated. And it says APC, which probably means actual physical control of an automobile. That's what he said he was charged with. So it probably means actual physical control of an automobile. And then it's got 47 Oklahoma statute section 11902A. That is the actual part of the criminal code that he's been charged with violating. Okay, that's the crime. If we open up the book of the criminal code and we turn to number 47, section 11902A, that's going to tell us the crime that he's been charged with, okay, what he is supposed to have done. Then it's got the information of the police officers who arrested him. It's got information about Bobby Plant. And then it's got a statement by the police officer reporting what happened that night. And I want to read it with you quickly, okay? At 1:10 a.m. on 11th December 2012, I was driving my marked patrol car, it's a police car, westbound in the 500 block of South Main Street in downtown Tulsa when I saw a white 2008 Toyota Camry sedan, Oklahoma license tag number KAZMIR, parked at the curb with its interior light on, so the light inside the car is on. I parked my car and approached the subject vehicle. Upon arrival, I observed an adult male seated in the front passenger seat. Now, we know in a car, we've got the driver's seat with the steering wheel, and then we've got the passenger seat where the person who's not driving the car is sitting. So the police officer saw Bobby Plant, right, seated in the passenger seat, not behind the steering wheel, but over in the seat next to him, okay, with his upper body slumped over in the driver's seat. So he's seated in the passenger seat, but he's laying over in the driver's seat behind the steering wheel. So his head and arms are behind the steering wheel, but the rest of his body is seated in the passenger seat. The vehicle's engine was not running, but the key was in the ignition and the radio was playing loudly. There were no other occupants, nobody else in the vehicle. I shined my flashlight into the vehicle and tapped several times on the window, but the subject appeared to be asleep. I then opened the driver's side door and with some difficulty awoke the subject, whom I later identified as Bobby Plant. His eyes were bloodshot and glassy, and he had the strong odor of alcohol on his breath. In addition, his speech was slurred. He wasn't talking properly. If you've ever been around someone who had too much to drink, you probably recognize these things, okay? They're classic signs or signals that someone's been drinking too much. I asked the subject to exit the vehicle, and he did so with great difficulty, stumbling as he stepped out of the passenger side. I then performed the standard field sobriety tests on the subject. These are tests that the police give people to see if they've had too much to drink. One is the police will ask you to say the alphabet backwards. So if you've been drinking, that can be very hard to do. Another is they'll say, put your arm out to the side and touch your nose, right? Touch the tip of your nose. Okay, if you have not been drinking, it's easy to do. If you drank too much, it's very difficult to do. You may miss your nose. So he gives Bobby Plant some of these tests. At the conclusion of these tests, I concluded the subject was under the influence of alcohol. In fact, he admitted to me that he had a lot to drink that night. I subsequently placed him under arrest for APC. Again, actual physical control. The subject was then taken to the Tulsa Police Department and given a breathalyzer. That's where you breathe into a machine and it tells you tells the police how much alcohol you've drank, which produced a reading of 0.11, which is illegal. It's above the allowed limit. A record check shows the vehicle to be registered to an unknown third person, Jonathan Bonham, and the vehicle was towed away by a record company. All right, we got all the facts now. We've got the statement of our client, our potential client, Mr. Plant, who doesn't remember much. We've got a much more detailed statement of facts by the police. What else do we need to tell him? Can we get you out of this, right? Can we help you out of this charge, being charged with this crime? What else do we need to see? We need to see the law. We got the facts, but now we need to understand the rule of law that applies to those facts, okay? What law? How about the law that was referenced in the police report, right? 47 Oklahoma statute 11902A. That's the law he was charged with violating. Okay, and here it is. If we open up the criminal code of Oklahoma and we turn to this page, this is what we would see. This is the real criminal law. So let's read under A. He's charged with violating 11902A. Let's read under A at the bottom. It is unlawful, illegal, right? And punishable as provided in this section for any person to drive, operate, or be in actual physical control of a motor vehicle within this state upon any public road who is intoxicated. So it's a crime to be drunk, right? To be intoxicated, and to drive a vehicle, to operate a vehicle, or to be in actual physical control of the vehicle. This is the law. This is what he's charged with violating. And I've read it, and I'm a lawyer. I've been a lawyer for nearly 25 years. And I have no idea what it means to be in actual physical control of a motor vehicle. I know what it means to drive it. I can guess what it means to operate. I mean, there are things you can do to a vehicle without driving it, but I don't know what it means to be in actual physical control of a motor vehicle. And this is the law. And this is all the law. This is the complete law. It doesn't tell us what it means. It says it is a crime to be in actual physical control of a motor vehicle while drunk, but it doesn't tell us what it means. That's a problem. How can we advise our client? Yes, you're guilty of this crime, or no, you're innocent of this crime, if we read the law and we don't understand what it means. Okay, can we now properly advise them? No, because we've read the law and we still don't know what the crime is, what's required to be guilty under this law. What do we still need to know? The definition of actual physical control. It's not apparent, it's not obvious from reading the law. Okay. Where can we find a definition for actual physical control? Well, think back to what I told you earlier. In the common law system, there are two primary sources of the law. One is the code, right? And that's what we look at. This is part of the criminal code. What's the other primary source? Decisions from courts, earlier cases. And that's what we're going to need here. Okay, how about a court decision where an earlier Oklahoma court has interpreted and applied that same law, that same part of the criminal code? And I went and found one for us. Okay, it's called State versus Kelly, Oklahoma Court of Civil Appeals. So middle appeals court from 2007. And here's what they said. One is guilty of actual physical control, where he or she exhibits existing or present bodily restraint, directing influence, domination, or regulation of an automobile while under the influence of intoxicating liquor. Now, if we stop there, I still don't know what it means. I don't know what it means to restrain a vehicle, to dominate a vehicle. I don't know what it means. Fortunately, the court continues, okay? They say, as is evident, as we can see from the line of even earlier Oklahoma cases. So that court in 2007, went back and looked at even earlier Oklahoma cases on actual physical control. And they said, as we can see from those cases, intoxicated occupants of motor vehicles do not have to be awake or conscious to be in actual physical control. So you can be guilty of this crime while you are asleep, which is odd to think about, if they are found behind the wheel. And by behind the wheel, we mean behind the steering wheel, and the keys are in the ignition, whether or not the engine is running. So you can be guilty of this crime, even if you're asleep, if you're behind the wheel, behind the steering wheel of the car, and the keys are in the ignition. Whether the car is on, off, it doesn't matter. Okay. In each case, in each of the earlier cases the court looked at, the fact that the men placed themselves behind the wheels of their vehicles while under the influence of alcohol was sufficient circumstantial evidence, was enough evidence to support the conclusion that they either had been driving while intoxicated or could have awakened at any moment and done so. And now I finally get it. Now I understand what the crime of actual physical control is about. What actual physical control is a crime, the reason it's a crime is because if it's only a crime to drive or operate a vehicle while drunk, right, while you're awake, then you could be asleep in this car. You could be behind the steering wheel in the driver's seat. You could have the key in the ignition, and a police officer could come by and he could see you in the car and he could smell the alcohol. He could see a bottle of alcohol and know you're drunk. But because you're not awake and you're not operating or driving the car, there's nothing he could do. There's nothing he could do. He would have to say, okay, carry on, have a nice evening. And then you could wake up 1 minute later and turn the key just a little bit and drive very quickly and kill yourself or kill someone else. If the law only said it's a crime to drive or operate the vehicle, then the police officer could see someone asleep in a car, clearly drunk, behind the wheel, keys in the ignition, and the police officer could do nothing. They would have to leave the person alone, and the person could wake up in 1 minute or 10 minutes and very quickly be driving on the road and kill someone. And so that's why this law exists. It says, look, if the police find you drunk in your car, if you're behind the wheel and your keys are right there ready to go, they can arrest you now. They don't have to wait until you drive out on the road and maybe kill someone. They can go ahead and arrest you now. Okay, now I get it. The code wasn't clear. The case makes it clear. All right. Can we now advise Bobby Plant about whether he is likely to be guilty of this crime of actual physical control? And I think we finally can. We can apply the definition from the Kelly case to the facts of Bobby's case, right? He's likely guilty of actual physical control if, one, he's found behind the wheel, and two, the vehicle's keys were in the ignition, whether or not the engine's running. This is good news for Mr. Plant. Why? Because he's not behind the wheel. He's not seated behind the wheel. He's seated in the passenger seat. Now, we could argue the government that's prosecuting him for the crime could say, well, part of him is behind the wheel, right? He's leaning over, his head. That's not what behind the wheel means. In the US, that's not what we mean. When we say someone is found behind the wheel, it means they're seated, their whole body is behind the wheel. He's not. The keys are in the ignition. That doesn't help him. But the fact that he is not behind the wheel means he cannot be guilty of this crime. So it's good news for Mr. Plant. All right. What did we just do? We didn't identify each of these steps, but what did we just do? Number one, we identified the legal issue. And the legal issue here was, is Bobby Plant guilty of the crime of actual physical control under Oklahoma law? Number two, we stated the rule of law. We looked at the law, we looked at the criminal code, and then we looked at a case interpreting the criminal code. And together that gives us the rule of law. Rule of law is right here. You're guilty of this crime if you're found behind the wheel and the keys are in the ignition. Number three, we applied that rule of law to the facts of Mr. Plant's case. We said, well, he wasn't behind the wheel. And then number four, we reached our conclusion that he will not likely be guilty of this crime. Issue, rule of law, apply it to reach your conclusion. That is called the IRAC method or structure, right? IRAC, issue, rule, application, conclusion. That is the fundamental tool of legal analysis in the common law legal system. That is the first thing I learned when I started law school in 1993, a long time ago. The IRAC method or structure is the very first thing I learned in law school because it is an extremely valuable tool for analyzing a legal issue in the common law system. Okay, done properly, the IRAC method ensures that we are analyzing legal issues based on the rule of law, based on the hierarchy of courts, right? So it's consistent with the decisions of higher courts, and also consistent with the principle of stare decisis, that lower courts are going to be bound by the earlier decisions of those earlier courts. If we do this properly, if we apply the IRAC method and structure properly, we are analyzing cases in a way that is consistent with the rule of law, which is the main point we're discussing today. Conclusion, I want to go back to the material on an earlier slide. And again, I said it's the most or one of the most important points I was making today, and it's about the principle of stare decisis. Okay, lower courts have to follow legal precedent established by higher courts within the same area, or what? Or they'll be reversed, right? Another higher court will say, you got it wrong, and they'll reverse it on appeal. And I said, stare decisis promotes stability, right? The law will remain somewhat consistent over time. Predictability, so that I can predict for Mr. Plant. Here's what's going to happen, right? You're going to be found guilty of this crime, so you should go ahead and plead guilty and get a lesser sentence. Or, no, I predict you're going to be found innocent of this crime because you're not behind the wheel. You should fight it. Don't plead guilty, fight it, right? It's this concept of stare decisis that lets me predict the outcome in the case. And then finally, fairness. Stare decisis promotes fairness because lower courts should apply the law consistently. They should apply it the same way to everyone. And I hope you can see that that is the relationship between the common law legal system and the rule of law, right? And a lack of corruption. Stare decisis is a huge part of that. It promotes fairness. It promotes one legal system, one system of laws that applies equally to everyone, regardless of who I am or what my position is. If I go to court and I know that that lower court is bound by the same earlier decisions of higher courts that every other lower court is bound by, then it helps me ensure that I will be treated fairly under the law. In both civil code and common law legal systems, the rule of law should result in the law being just and fair to all. This is a quote from our earlier slide. The law should be clear, publicized, and stable. It should be applied evenly and should protect fundamental rights, including the security of persons, including their ability to contract, engage in business, and also their fundamental human rights. And in the common law legal system, it's this principle of stare decisis that helps to ensure the just and fair application of the rule of law to everyone. Okay, that's all I have. Moderator, I don't know if you have any questions that
Yeah.
people have you want to present.
Yeah, thank you very much, Professor Henry Webb.
Sure.
Yeah, thank you very much. It was very interesting. I'm happy to tell you that there are lots of questions from the students.
Okay.
This shows how enthusiastic they are. And this does remind me of, yeah, students in Indonesia in the past, if you remember, in 1998, they became one of the agents of change, reformasi, if you remember that, reformasi. So yeah, so this is a good topic when you mentioned about bribery, corruption. It does resonate with all of us here. Thank you for your talk about that, and also the lecture on the common law system, which and you have mentioned that Indonesia is pretty much using I think the civil code legal system.
Right.
Yeah, but it's interesting to know about the common law. There are many participants and questions from Malaysia. And I don't know, in Malaysia, is it common law? I think it is common law system that they're using. I'm not sure. All right, so let's just go to the first question. It's from Rafif Putra Nur Ramadan from ITS Surabaya. So he said that corruption typically involves bribery with money. Is there any such thing as corruption that does not involve money? That's the question.
Sure. Oh, yeah. Yeah, I mean, money is most common because that's our medium of exchange. That's how most people buy and sell things. But there is corruption. Any favor that you are doing for a government official that results in them giving you special treatment, that's still corruption, right? If I mean, there are real cases where I want a government official to do something for me, so I go and build them a home, or I give them a piece of land, or I find a girlfriend for them, right? I'm trying to be very general how I say this, but it doesn't have to involve actual cash. It can be any type of favor that I'm doing behind the scenes unofficially for this government official. If they give me special treatment based on me doing a favor for them behind the scenes unofficially, then that is also corrupt. Yes.
All right. Okay, thank you. So the next question is from Izani Nur Atira Ibrahim from University of Technology Mara in Malaysia. She's asking, how can the world protect the indigenous legally?
Well, that's, yeah.
Yes.
I mean, it's a great question, and sadly, indigenous peoples, and this is true in the U.S. and with the Native Americans, and it's true in Australia with the Aborigines, and it's true in Vietnam where I live with the tribal people there. Sadly, they tend to be some of the weakest people in a society, some of the people with the fewest rights or the least amount of power. Now, if we do have a system that applies the rule of law properly and fairly, they should be treated like everybody else. And there should not be a distinction between an indigenous person and a later arriving person, for example. So I guess my answer, I mean, how can we protect them? I think they're a special case, and we need to affirmatively, proactively try to make sure that their rights are protected. But I also think in a system that applies the rule of law properly, they're going to be treated fairly no matter what, whether they're indigenous, whether they're later arriving, they're going to be treated fairly anyway. So I don't want to say we shouldn't look out for them and try to take care of them because of their low power in many societies. But if we really apply the rule of law properly, they're going to be taken care of anyway.
Okay. Can I try to call Izani Nur Atira? You want to add to your question, or is that enough? Is it Izati, or is it Izani Nur Atira? Okay, so let's move on to the next question then. The next question is from Marshanda Febriana Putri from ITS Surabaya. I'll just read out the question as it is. You said that the corruption is the opposite of law. Then what happens if the people who corrupt are those who create the law or constitution? Why do these people break their own rules that is created by themselves?
Well, it comes down to greed, right? It comes down to, if I'm in a position of power and I have the power to write the laws, and I can write the law itself in a way that benefits me directly, well, that's great. That's to my advantage, right? It's money in my pocket. So it's just, I mean, I don't want to say that human nature is to be greedy, but when you look around, it's hard not to say that, because people do tend to do what's best for themselves. So I think there's two questions here. If I can write the law so that it benefits me, that's one thing. The other thing I can do is I can write the law in a way that I know how to get around the law. So on the one hand, I can make the law where it directly benefits me. On the other, I may write the law in a way that I can avoid the law and avoid the consequences under the law because I wrote it and I know how it works. It is one of the weaknesses of a democratic system, that greed and that human nature to advance yourself, to do what's best for yourself in your own self-interest. It's hard to avoid those people writing the laws in a way that benefits them. I'll give you an example, and this goes to the earlier question as well, because it doesn't involve money, but it is also an example of corruption, I think. In the U.S., the laws are written by our legislature, right? By the senators and congressmen. And in our legislature, there are no term limits. So the president can do 2 4-year terms. So Barack Obama he was president for as long as he could be, right? He was president for a 4-year term from 2008 to 2012, and then he won a second 4-year term from 2012 to 2016. Senators and congressmen and women are unlimited. They can be a senator or a congressperson for as long as they keep getting elected. Joe Biden, who's about to be the president in the US, he was a senator for 47 years. Okay, think about that. For 47 years, he's been a senator and he's had power. And I'm not saying that he's done this, but he's potentially in a position to write the laws in a way that benefit him and his family for 47 years. And that's improper in my opinion. And one of the things I would push in the US to try to enforce the rule of law and strengthen the rule of law and to reduce corruption is I would like to see term limits for senators and congressmen and women. But here's the problem, and this goes to the student's question. They write the laws. They're not gonna pass a law that limits their own power. They want to be in power for 47 years. They want to be able to benefit themselves and their families for as long as they can. And they write the laws. So my hope that there would be term limits on them, it will never happen, in my opinion, because they write the laws and they will not write a law that reduces their own power.
Okay, thank you. The next question is from Naufal Adli Purnama from ITS Surabaya. Let me read the question as it is. Vietnam and Indonesia are countries with pretty low transparency scores. Both are developing countries whose economies aren't as large as the US or West European countries, and that makes it more tempting to accept bribes. So how do we ensure the enforcement of laws that have been legislated? Thank you for your time.
That's a great question. And I want to be clear. I do not mean to pick on Vietnam or Indonesia or any developing country, because I think the US also has major problems with corruption and bribery. And I think in the US it's worse in some ways because it's not policemen asking somebody for $25. It's millions and billions of dollars. And it's done at the level of large government and large companies and large institutions. Okay, so I do not mean to pick on Vietnam or Indonesia or any developing country, because I think even some of the most established and developed countries in the world have these same issues, if not worse issues involving this. But when you ask the question, how can we stop it? It comes down to law enforcement, right? And it comes down to the political will of the people to punish this behavior, to not accept it as business as usual, to not accept that policemen in Vietnam just stand out in public and stop people and take money from them all day long. That should be a crime itself, right? If the police officer is pulling people over for speeding and not giving them a ticket and just taking money that's a crime. So the answer to how you make this go away is there has to be this political willpower of the people and the government to treat this seriously and to say, look, we may have always done it this way, but no more. And I'm not an expert on this, but I think Singapore is supposedly a good example of this. I think when Lee Kuan Yew took over in Singapore, he was very, very strict about punishing bribery and corruption. And I'm not saying it doesn't exist, because I think it exists everywhere. But I would guess that there is much less corruption in Singapore than in some other developing countries for that reason. But the most direct answer to that student's question is you have to have the willpower to be willing to enforce the laws and to impose very strict penalties on people who are corrupt and who do take bribes.
All right, thank you for the answer. Yeah, just to add a bit about the will. I think in general the people does have the will, but yeah, we still have to look into our daily behavior for that before saying that we're not in the guilty position here. But regarding the will, in Indonesia we have KPK, Komisi Pemberantasan Korupsi, which means the Corruption Eradication Commission, if you're familiar with that. That's one of the how the Indonesian people have this will to somehow eradicate corruption. Just yeah, just to let you know about the KPK. All right, let's move on to the next question. Here's this a question from Nadine Natasha Nabila. I think this also represents myself. So she recommends no, she recommends, she's asking for a recommendation on books, podcast, or any media recommendation to know more about the basics of law, because she really thanks for your she really thanks you for your presentation. She gains a lot of new knowledge from that. She doesn't know much about law, but she wants to know more. So do you have any recommendations of books or
Yeah,
podcasts? Or
I do. Could I email you a list of a few very good books on the law, and then maybe you could provide it to all of the participants? I think that'd be the best way to do
right,
that.
right. Yeah,
Yeah,
okay.
there are a number of books at various different levels of complexity on the topic. I think she's wanting like an introduction to the topic, and I know of a few books, but I'll get their information and their ISBN number and give it to you, and she'll have the author and the title and the ISBN, and you can share that with all of the students, and hopefully that'll be a good resource for them.
Okay, thank you for that.
Sure. And I'm glad she enjoyed the presentation. And as I mentioned at the beginning, you know, my real hope is that I can come to ITS and present in person. I teach short courses as visiting professor all over the world. In 2021, I'm teaching 2 to 3 week courses in Vietnam. I'm teaching one in Mongolia. And I've also got a Fulbright grant where I'm going to teach in Bhutan, up in the Himalayan mountains near Tibet for 4 months. So I mean, international education is my focus. And I would certainly, once COVID is behind us, I would certainly welcome the opportunity to come and meet you guys in person. So thank you for that.
Okay. So yeah, so she also mentioned that she prefers something with a lighter language and clear explanation. If that
Okay. Yeah.
helps.
Yeah.
Okay, thank you. The next question is from Asman from University Teknologi Mara in Malaysia. Before I read the question, maybe I'll just invite Asman. Is Asman here? You can just unmute yourself if you're here, if you would like to ask the questions in your own words, because it's quite long. Asman, are you there? If not, I will just read the question. So, sir, what is your opinion about misleading in the reinforcement of law, especially between people with high status and people with low status? And in certain situations, the people with low status and poor unable to fight for their stand, especially when it comes to lawsuit, or did not have connection with powerful people as with high status people did. Also, how far the law can promise justice for the society as a whole.
What was the last part? How
far the law can promise justice for the society as a whole.
So the law should promise justice, and the law does, in most cases, promise justice. And how far should they go in promising that? They should go as far as they can, because that should be the standard, right? Everyone in society, regardless of your status, regardless of your wealth or your poverty, everyone should have the law applied to them justly, fairly. So they should go as far as they can in promising that. The problem is what they promise and reality are two different things. And that goes to the first part of your question. Powerful people, wealthy people, there's no question they have an advantage in the legal system. There's a case going on in the US right now, and it involves a company called Theranos, Theranos. And the former leader of that company is a woman named Elizabeth Holmes. I think that's her name. And she engaged in fraud. She raised money, millions of dollars for her company by lying to people, by lying to investors, by saying that her company had technology that it did not really have. She just lied. And she stole millions of dollars from people. And now they're getting ready to have her trial. And because of the millions of dollars that she stole from these people, she's got the money to hire the very best lawyers in America. She's got lawyers that charge $1,000 an hour for their time representing her. Okay. I couldn't do that. You know, most people in America could not do that. So she's rich because she stole, and yet because she stole, she has the money to hire the very best lawyers and to have a real advantage in the legal system. So it's a huge problem. It's always been a problem. People who are connected politically, people who know judges and who know lawyers and who know people in the government have a huge advantage over everyone else. People who are wealthy and have the money to pay these bribes and to hire these lawyers and to pay off these judges, they have a huge advantage over everyone else. So I think to tie your two questions together, ideally, yeah, the law should be just and it should be fair and it should promise as much as it can that it will be just and fair. The sad thing is in reality on a day-to-day basis, in every society I'm aware of, it's the powerful, connected, and wealthy people who have an unfair advantage.
All right, thank you. Next question is from Indonesia again. Ahsanul Hadinugraha from ITS Surabaya is asking, can the common law become a civil code? If they can, does it need further testing? If they can't, and the common law was proven to contradict with the existing civil code with a horrible punishment, for example, death sentence, does the judge loses their job and put on trial?
Okay, so that is a great question. I should have mentioned that in my presentation because that is something that does happen, okay? The courts can create law. They can create new rules of law in disputes that they're deciding, right? In actual cases they're deciding. And so many courts can start to follow that rule of law and apply that rule of law that the government then makes it part of the code. So the government may not have had the idea to make the code say that, but because courts adopted that rule, and so many courts adopted it that it became law in a large part of the country, then the government can say, you know what, that's a great idea, that's a great rule, we need to write that into the code. And there are many examples of common law concepts that were created by judges that later became so popular and seemed like such a good rule of law to have that the government made it part of the code. So that's a great question, and it does have a lot of contract law. For example, most contract law about doing business by contract originated in the courts. It started out in courts deciding these cases. But a lot of those principles, a lot of those concepts were later made part of the code. Now, I think a second part of your question was, what if there's a conflict between the code and common law? And the answer is the code always wins. The judge's power to make law, the court's power to make law is secondary to the government's power to make law, to the legislature's power to make law. And not to get too detailed, but that's because under the Constitution, the very first article, the very first section of the US Constitution gives the legislature the power to make law and the responsibility to make law, okay? It's a later section that creates the court system and gives them their powers to interpret and apply the law. So their power is recognized as being secondary to the legislatures. And that's why if there's ever a conflict between the code and common law, the code always wins. Was there another part of that question that I didn't?
I think that's it. So I hope that already answers the question.
Okay.
Yeah, there are two parts. So the last one about whether if it does contradict, then the what do you call it? The code wins, right? Because it has a higher precedence.
Right.
Than...
Oh, she said, would a judge lose his job if he ruled?
Yeah.
You know, there's kind of protections against that, because if it's at a lower level, at the trial court, for example, if the judge gets it wrong, he's not going to lose his job. But if the party who loses appeals it to the next highest court, they're going to reverse it. They're going to say, you got it wrong, judge, right? And some judges are elected. They have to be elected every 4 years. And so a judge who kept making the wrong decision and kept making bad decisions and getting reversed, he probably would not be reelected, because the people would realize he's a bad judge and doesn't know what he's talking about. But it's not an immediate thing like, oh, you made a bad decision, we're going to carry you out of the courthouse. You lose your job immediately. Now, the other thing I would say is, as you get up higher in the hierarchy of courts, you're not just talking about one judge. You're usually talking about a panel of judges. So the US Supreme Court, for example, it's not one judge, it's 9 judges, 9. And the majority, the way the majority rules decides the case. So 5 judges have to, at least 5 judges have to decide the law a certain way for that to be the result of the case. So I think it goes to your question that it's not just one judge who's making a decision. You would have to convince 5 judges at the Supreme Court level to rule in your favor. And the odds are that that's going to be a more honest process, right? Because it's not just one judge who may take a bribe or rule in your favor because he knows you or has some connection to you like that. It would have to be 5 very, very high level judges who agree with your position in the case.
Okay. All right. Thank you. The next question is from Nur Farain binti Lila from UITM Shah Alam, Malaysia. So her question is this, I'll just read it as it is. Hello, I just want to ask, is there any example of a case where assumptions was made in the courtroom led to a verdict that was clearly wrong? If yes, what is the effect of this incident?
Yeah, there have been cases, and there have been many criminal cases where someone was convicted of a crime, and then later it was determined that there was no way they could have committed that crime. And a really common example of that these days is with DNA evidence, because 20 years ago, when people were being sentenced for crimes, the technology to measure DNA and to identify people by their DNA was not nearly as good as it is now. And so you have somebody who 20 or 30 years ago was convicted of a crime and has been in prison for 20 or 30 years. And then in 2020, they finally go back and test that DNA and they find out it wasn't that person at all. It couldn't have been that person. The effect of that is, in most cases, they will either be released or they will have, at least they will have a chance to have a new trial. And they may win or they may lose. And if the DNA, if the new evidence is really in their favor, then hopefully they can win. Sometimes they don't even, if it's very, very clear, they don't even make them have a new trial. They will just release them. But it's a very sad thing, and it's a very frightening thing. Can you imagine sitting in prison for 20 or 30 years, knowing that you didn't do it, knowing you're innocent, and then taking that long before somebody figures out, oh, it could not have been him, and releasing you, right? It's a very frightening thing, and sadly, it does happen.
Okay, yeah. Thank you for the answer. And the next question is from Izani Nur Altira Ibrahim again. So she has 2 questions. Can I try to call her again? Izani Nur Altira, are you there? Please unmute your mic if you can. Oh, hi. please mention your questions directly.
Okay, can you hear me?
Yes, we can hear you. Please.
Okay, actually, I have sent 2 more questions. So the first one is actually related to the previously that Professor have answered. So it is actually how does the rules, I mean, in the city, there is rules and regulation for everyone. But in some parts of rural area, I mean, the regulations, like, for example, let us take one regulation about pipeline or sewage system. So the pipeline or the concept of the clean water and also the disposal system is not applied in the, I was like wondering, are they didn't deserve this clean water and also the proper disposal system for them, and how is these SDGs I mean sustainable development goals applied to them if the rules were not complied to them.
I only heard part of that.
Yeah.
Do you have her question in writing?
Try to repeat
I start to think about the first question.
Miss Izani, excuse me, Miss Izani, you're breaking
You have
up.
answered, which is you mentioned that these are rules
Okay. I think we have a connection problem with Miss Izani. From my side, I can't hear anything any longer. All right. Okay. Okay. So let me just repeat the questions again. So the first question from her is, in a city, there are always rules and regulation on how everything works. Let's take housing rules, for example, pipelines, sewerage system. But for people who live in rural areas, aren't they need a clean water and proper disposal system too? How does the world stand for them so that this SDGs could be applied to everyone? That's the first question.
Okay.
The next one is about, um, I'll just read it. How does the publicized law illustrate in law world? I mean, for those who lived in the city might know about this stuff, but people who live outside the country, we can say the situation is vice versa. How to make everybody acknowledge the law? The law comes to people, or people come to law?
Yeah, I think she's still talking, so I want to
Yeah,
wait.
excuse me, Miss Izani. Hello, hello. Can she see us? Hello, Miss Izani.
Sure. I don't want to talk.
You can you
Miss
hear
Izani,
me?
we cannot hear you.
Not
It's
well.
breaking up. We cannot hear you. I'm sorry. We cannot hear you. We can see you, but we can't hear you. Okay.
Okay. I I think her question is similar. I'm not sure if she's the same person who asked the question about indigenous people earlier, but it's a
Yes.
similar issue, right?
Yeah.
It is the same. Okay, it's a
Same.
similar issue because you're talking about a relatively weak section of the population. And it's not always the case, but she says, in cities, the laws are very clear and everyone knows what their rights are. And in the countryside, a lot of people don't. That that's a matter of education, right? It's a matter of what information people are exposed to or have access to. And it's true in Vietnam and it's true in the US. People in many rural areas don't have as good of an education and they don't have access to the same information that wealthy people and connected people in the cities tend to have. The centers of power in most countries tend to be the cities because that's where the wealth is consolidated. That's where the political power is consolidated. That's where people have better educations, generally speaking. So it's an issue in every country that I'm aware of, and it is a basic inequality. And I think she's right. The people in the countryside, the law should apply fairly and equally to them as it does to people in the city. And on paper, it does. If you read the law, yes, people in the countryside should have clean water and should have sanitary conditions, right? The law says that they should. The problem is who's going to enforce that law on their behalf? And it's the same as with the indigenous people. Who's going to protect them? Who's going to fight for them? And the answer, sadly, in many cases, is no one. No one, right? So on paper, yeah, the law says you're entitled to these things. But in reality, you go visit those places in the countryside and they don't have clean water and they don't have proper sewage or sanitation. And it's not that the law doesn't say they should, it's that who's going to insist that they do? Who's going to fight for them and enforce the law on their behalf? The last part of her question was about publicizing the law. It's the same thing, right? The law is out there. I, I, I don't know this for a fact, but I imagine in Indonesia and Malaysia, just like in the US, you can go on the internet probably and find the law. Okay, it may not be easy to find, but it's probably out there. If what if you're in the countryside and you're poorly educated, or you don't have internet access, or you can't read, right? You're illiterate. How can you do it? So it's in my opinion, it's not that the law is not publicized. It's not that it's not out there. It's more of a matter of there are certain people who, because of a lack of education and a lack of money and a lack of internet access, which may be related to a lack of money, but they don't have the ability to go and find this information, even though it is publicized. And they don't have the ability, even if they find it, to really read it and understand how it applies to them and how they can enforce their rights under the law. So the solution to this is education and development and economic advancement for everyone, city, countryside, it doesn't matter. The solution and it's really the solution to many, many problems, is better education and economic development that lifts everyone, not just people in the city.
All right, thank you. There's one raising their hand. Shakirin Noderi, please, you can unmute yourself and ask your question.
Hello, Professor.
Hello.
Yes, I have a question about Anti-Money Laundering Act. Okay, most countries are equipped with such act, like in my country itself, but some countries like Cayman Island is not, because we learned that many of the richers and the wealthies, they prefer to hide their money and launder their money where there is no such Anti-Money Laundering Act. So coming back to the question, why certain countries do not pitch such legislation, even though we know that this kind of act is beneficial to the economy and the social of the people.
Do you have a guess? Do you have a theory as to why they would not have that law? I have a theory, but do you have one?
Not at the moment.
Okay. Here's my guess. It's because the people who write the laws benefit from not having this law, right? If I'm part of the government, and if I am personally making a lot of money by allowing rich people to come into my country and launder their money here, if I'm getting paid a percentage of that, why am I going to change that, right? It goes back to what we said earlier about people being greedy and people acting in their own self-interest. So that's my theory. I don't know in a particular country why they would not have one, but that would be my guess. And I bet it's a very good guess. People do not they do not usually change laws that benefit them personally, right? Why would I change them? Even though it would be better for the country and everyone in the country as a whole. Why would I change that if it's putting millions of dollars in my pocket? Okay. There are certain countries that are known to be money laundering destinations. And people know I can route my money through that country and it comes out clean and I don't have to pay tax on it, right? And I don't have to reveal the source of it. Well, somebody's making money off of that system. And they're either part of the government or they're paying people in the government not to change that law. It comes down to greed and it comes down to benefit. That's my theory.
Okay, thank you, Prof.
Okay, thank you very much. I'll read the next question. It's from Ikuo Kresna Bayu Amarta from ITS Surabaya. He's probably similar to me. I think we enjoy watching TV series on criminal investigation. So he's asking, what if the higher courts make mistake? Will the lower courts still follow the legal precedents? And I wonder, where was Mr. Plant's friend gone? Bobby Plant's friend.
Yeah, who knows? I don't know. It's a mystery. I don't know what happened to him. Yeah, maybe. I don't want to speculate. I don't want to speculate. But somehow Mr. Plant ended up in the car by himself. Maybe he was acting so ugly his friend abandoned him for the night. I don't know. But your first question, you said if a higher court makes a mistake,
will the lower court still follow the legal precedent? It's
a great question. I mean, really, they have to. Okay, there's really no mechanism by which a lower court can say we're not going to follow that law. They could do it, but they're going to be overturned on appeal. And ultimately, it's going to go back up to that same higher court, right? And they're not going to be happy. They're going to say, well, you can think we made a mistake, but this is how we see the law, and this is how we think it should be applied, and you're lower than us. And so unless and until we change our mind and agree with you, you've got to follow us. So, they could do it. They could say, well, we disagree and we're not going to follow it. But eventually that same higher court that made the decision is going to overrule them, and their decision is not going to have any weight. It's not going to impact anything going forward. It's just the way the system is designed is the higher courts do have the power to decide what the law is, and lower courts in that same area have to follow it.
Yeah, so that's the principle of stare decisis, right?
That's right.
Yeah. So that's applicable in common law legal system. How about in civil code legal system? Does that apply to? When I was in high school, I remember being taught about, we call this jurisprudency. I don't know how you said in English. It's jurisprudence, I think.
Yeah.
Jurisprudensia.
Yeah.
So it's a bit different from stare decisis. So the courts can make some decisions, and it can become a guideline for other cases, but not a new law. Maybe
Yeah,
just a guideline. Just a,
it's
I don't know.
generally, that's a great way of describing it. It is more of a guideline. And I know in Vietnam and in Qatar, where I lived and taught before, both are civil code systems, okay? Both have some concept of legal precedent. Like courts, judges can look at earlier decisions, but they are more of a guideline and they're not binding, right? The judge doesn't have to follow them. That's the difference. Okay, a judge in Qatar can look back and say, oh, I see 3 years ago, a judge in a different case said this is the law, and I like that, and I'm going to follow it. I think it's a good rule of law, but I don't have to. Okay, I can rule any way I want. So that's a fundamental difference. In the common law legal system, the decision of a higher court is truly binding. You must follow it. If you don't, your decision will be thrown out. It will be reversed. Whereas in civil code countries, as you mentioned, it's more of a guideline. They can look back and see how previous courts have decided, but they're not binding. They don't have to follow.
Okay, thank you. The next question is from Rangga Kusuma Dinata from ITS Surabaya. Okay, so this is where we can try to combine your talk with technology. What kind of the closest technology you're imagining to be developed shortly that would achieve goal number 16 of SDGs faster?
Oh my gosh.
Well, maybe the openness, the accessibility, I don't know.
Yeah, I mean, look, I think the internet, I mean, this is not something that's about to be developed, but it's still a fairly new technology. I mean, look what we're doing right now. I'm standing in my office at a university in Pennsylvania in the United States, and I'm talking to 100 people in Indonesia and Malaysia, and it's not perfect, but generally I think you can see and hear me well, and I can see and hear most of you well. Before the internet, this is a dream. It's a dream. You know, even to call, if I wanted to call you and have a short conversation, it costs so much money, the long distance fees and all of this. I mean, the internet has made the world so much smaller, and the internet is creating so many opportunities for people and exposing people. This goes back to the other students' questions about people in the countryside and indigenous people and publicizing the law. We literally have access to all of the information in the world right from our homes. Now, we may spend our time accessing gossip and news about movie stars and sports and things like this, but we could be looking up the law and looking up serious things, right? I think, as I mentioned before, I think the answer to a lot of these issues that students are raising, a lot of these problems that we face, is development. And it's improving people's economic status and improving their economic conditions. And I think any technology that can boost development in a country and speed development in a country and increase education and increase people's economic ability to earn, right? To be truly middle class and to have some extra income and not just be trying to survive from 1 month to the next. I think any technology that can create those opportunities helps to promote fairness and equality and to promote the rule of law around the world. You guys are the technologists, so I can only describe them very generally. You have to invent them and design them and put them in place. But I think anything that creates opportunity for people, especially in developing countries, can only benefit everyone from a fairness and rule of law perspective.
Okay, thank you very much for that very insightful answer. Thank you. That marks the last question from the participants, and also the time seems to be running out. We're 10 minutes to 9. So I think I'll just end the questions and answers session here. Thank you very much, Professor Henry, for the talk and the discussions. Very lively discussion. Very interesting. We hope that you can come visit ITS one day after
Well, thank
the
you
pandemic.
very much. I wish I could see all of you. I know we have so many people, it's hard to see everyone, but it's been very interesting for me. You guys asked excellent questions. I would never admit this to my students here, but you ask better questions than my American students here. So I do hope I can come and meet you all in person. And if you have any questions, feel free. My email address is right on the screen there. Feel free to email me individually. I will also send the moderator a list of a few very good books about common law legal system for people who are interested in more information. And thank you all very much for your time.
Thank you. Thank you very much. I'll give the time back to the MC, Miss Desi.
Okay.
Right,
Thank you very much, Professor Webb, for the excellent lecture today. And thank you, Dr. Irfan, for conducting this amazing session. Please give applause to our speaker and moderator by using the Zoom reaction feature. Okay. Furthermore, we would like to present a certificate awarding to both of our speaker and also our moderator for today.
Thank you very much.
And this is the certificate presented for Dr. Irfan. Very much, Professor Webb and Dr. Irfan, for your time.
Thank you.
Before we end, I'd like to invite all the participants as well as the honorable participant, please turn on your camera. And I will count to 3. Okay. 1, 2, 3. One more time. 1, 2, 3. Great. Now that we have finished our group photo, for the participant, please fill the feedback form through the link bit.ly/feedbackgls that you can also see on the Zoom chat room. The deadline for filling the feedback form is 15 minutes. Start from now. And we want to remind you the participant who will get the stamp is the participant who come on time, join this event until the end, and also fill the feedback form. And finally, we have reached the end of today's guest lecture series. We sincerely apologize for any mistakes we may have made in presenting as Master of Ceremony and Committee. Thank you very much for Professor Webb and Dr. Irfan and all participants for the attention and cooperation. We will see you in the next guest lecture series on SDGs next week. Good evening and wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Thank you.
Thank
Bye-bye.
you.
Thank you, Professor Henry Webb. So just to confirm, clarify, okay, maybe Professor Webb has left. Okay, no worries. Okay. Thank you everyone for joining. It was very, very interesting, beyond my expectation. And sorry for any mistakes that I have done. So thank you, Miss Desi, Mbak Nastiti, everyone.
Thank you also to you, Dr. Irfan.
Thank you. Thank you.
And everyone, thank you so much for coming to 2 sessions of today's session. We are so happy to welcome you in our GLS and really appreciate your attendance on this afternoon's and this evening session. And also, I found that you found problem in the feedback form. We will revise it and so we will revise it soon so that you can fill in the feedback sooner. Thank you so much. Thank you so much once again. Thank you, Dr. Irfan. And permission to end the session in 5, 4, 3, 2, 1. Goodbye.